Hello, seniors. Welcome to your next part of your AP Government exam. This portion is going to cover over the Judicial Branch. So, to get started, make sure that you know your basic reasons for which the court system is established. I told you there are a few court cases you need to know. Marbury versus Madison, judicial review being number one. McCullough versus Maryland, giving that sort of supremacy clause, making sure that we know that the federal courts are more important, is another big one to know. But Marbury versus Madison should be one that you could say in your sleep. Make sure that you could answer as questions such as this. Okay, make sure you know the structure of the court system, that it goes federal district court, then the appellate court, then the Supreme Court. I don't know that it's terribly important to know all the ins and outs of each one, so long as you could outline why we have this court system in the way that we do, the 94 district courts, what exactly they handle. I think that would be key. The appellate court is the next level. Remember, there are 13 of these. And they really only hear questions of the law, so they are not what we would think of as a trial court. The next is the Supreme Court. Remember, they do not hear a lot of cases. They have original jurisdiction sometimes, but really only very seldom is this the case. We have what's called a dual court system, where there's the court system of the Fed and of the 50 states. So depending on what you've done, depending on the jurisdiction, you are going to go to one or the other. Article 3 of the Constitution is what establishes this. So your jurisdiction, do not forget the types. Your concurrent is both could be tried in either federal or state. Original, meaning who has the power to hear it first. Appellate, where it goes second. So make sure that you remember what jurisdiction is, just the power to say the law, and who exactly has jurisdiction when. Okay, make sure you could answer a question such as this. Okay. Make sure you understand how the Supreme Court works, basically the writ of centari, the oral argument. Make sure you know the reasons for which Supreme Court justices write opinions. So majority opinion is like what everyone thought. So in Brown versus Board, the idea that segregation cannot stand. A dissenting opinion would have been an opinion that said, no, segregation should be allowed to be still a thing. We talked about two different types of thought on how the judicial branch should act. We talked about judicial activism versus judicial restraint. Judicial activism meaning justices are going there actively trying to change the law based on the cases they are taking, things like this. Judicial restraint means that justices are holding themselves back. They're really only taking questions when they feel that they really do have a reason to be hearing this. Make sure you know the time periods by which we had lots of different ideas as far as the courts. Definitely know the Warren Court, which we say is the most liberal court ever. This is Brown versus Board, Gideon versus Wainwright, Miranda versus Arizona. Many of the rights that you feel that you have came from this Warren Court. Make sure that you could talk about how the courts change over time and how maybe a chief justice's things that he wants to get across could highly influence what is going on in the court itself. Okay, question. Make sure you can answer it. Okay, here's an example of a short answer question that we talked about. Make sure you could talk about how the Supreme Court is perhaps not as much above politics and how interest groups could sway them. Here's another. Again, make sure you could answer it. All right, that is it for the judicial branch. I would also make sure that you review the things over civil liberties over court cases. I will be back with a presentation over that.